I don't know. May I please address? My lord, item number 3, my lord. I pay for adjournment, my lord.
Why?
My senior is some medical emergency, my lord. Okay.
This request is made to adjourn the matter on behalf of the Learned Council, Mr. Botakur.
Yes, my lord.
List after 4 weeks.
My lord. Deeply obliged.
The other side has no objection. List after 4 weeks.
My lord. Highly obliged. May it please, my lords, like to mention one item for listing on Friday, my lord. RDC.
What is the matter about?
My lord, we'll miss the next promotional interview, my lord. Otherwise,
No, is it a writ appeal or a writ petition?
my lord.
Is it a writ appeal or a writ petition?
Writ appeal, my lord.
Appeal. What is the order of date of the order of single bench?
19/11/2022.
So now you've woken up.
My lord, we had filed, but it was in defect, my lord. It has not been listed yet.
19/11/22. That means it must be delayed.
My lord, writ petition also we had filed. We have come for writ appeal, my lord. Our seniority was
We
intended.
are asking you, gentlemen,
My lord.
if you file now, you are asking for a fresh listing.
My lord.
The order is of November 22.
My lord.
Then your appeal is bound to be delayed.
My lord, it has.
Obviously. So then if you yourself were so leisurely proceeding at such a leisurely pace, what is the urgency then?
My lord, next promotional interview.
But then we are asking you, sir, November 22 order, why didn't you file an appeal in time? When did you present the appeal?
My lord, we had filed it this year only.
This year, sir, 6 months have passed.
Right.
Which month? What is the date of presentation? Just let us know.
My lord.
Then we'll gauge what is your urgency. Okay, let us know. We'll take it thereafter. Yes.
My lord, item number 4, my lord. My lord, in this case, we are newly engaged, my lord. We need some time to go through the record, my lord. We come after vacation, my lord. We'll file the Ogalatama, my lord, newly.
Appointment. All right. And Council, Mr. Sohn submits. What's your good name?
As Hazarika, my lord.
Yes, Hazarika submits that he has been engaged on behalf of the review applicant recently herein before and needs some time to prepare the case. List after 4 weeks as per.
Deeply obliged.
It is your lordship. Lordship, I beg to mention item number 10, lordship. And this matter, lordship, an affidavit in opposition has been filed by the respondent authority, lordship. We need some time to file our.
You are for the appellants, the
The
petitioner.
Yes, Lord.
And Councillor Mr. So submits that affidavit in opposition has been filed on behalf of the respondents herein before, and some time is required to file an affidavit in reply. List up to 4 weeks.
Obliged, lordship.
My lord, in respect to item number 13, my lord, with consent of the respondent, I pray for 3 weeks time to file reply, rejoinder.
And counsel for the petitioner, page 4 is granted. 4 weeks time to file rejoinder affidavit.
Yes.
May I please your lordship? Lordship, I'm praying for a listing of a PIL on 30th, your lordship, next Friday, your lordship.
What is the matter about, sir?
My lordship, there is an Assam Gram Adarsh Yojana, your lordship. Under this scheme, there has to prepare a construction committee, your lordship. This construction committee has been made, my lordship, violating the guidelines of the mayor.
Listed on Friday.
Highly obliged, my lordship. I'm grateful.
We have preferred a writ appeal against the judgment dated 26/6/2023. I pray for listing of this appeal day after tomorrow. But one submission I have, the judgment has been passed by lordship's Honorable Justice D. Boga. Lordship, may kindly, lordship, all of it.
We have to constitute another bench for hearing that. No, because they don't know. Come on. Mr. Nath, it will be very difficult for your matter to be listed because there is one division bench only. Almost 7 judges are not available on 30th. 7 to 8 judges. So how will? What is the order of the single bench? There is another bench. Very well. We'll see. it will come up before the appropriate bench.
Lordship,
This instruction there. DB too many. Special DB. Okay. Yes.
Very clear, Lordship. Lordship, we have preferred a writ appeal. Against a judgment order dated 31/5, Lordship.
Mhm.
Now it's a matter relating to requisition and eviction, Lordship. Can it be listed on 30th
Oh, yes. Friday.
Friday?
Sure.
May it please your lordship. There is a writ appeal, my lord. Can it be listed just after vacation, my lord?
Just after vacation, it will come up on its own. Why do you need permission then? Everything is being listed. Fresh matters are being listed the third day, not beyond that. It will come up. Don't worry.
Right.
Yes.
May it please,
Hmm.
my lord.
What is the rate of filing?
My lord, December 21, 2022.
So why you are not pursuing it?
My lord, it was in defect.
Oh, so 6 months it took for you to remove the defects, and suddenly now there is an urgency. Hmm? What about that? Get it listed after vacations.
My,
After vacations.
my date may be given.
That the registry will list it automatically.
Highly obliged, highly obliged.
Lordship, I beg to mention item number 9. Yeah, Senior is suffering fever and throat
It is
infection
stated that
and
arguing counsel, Mr. So-and-so is unwell. A prayer is made to adjourn the matter. List after 6 weeks. Not interested actually. This has been listed a number of times before us.
Take your place.
Yes.
Daily list for orders item 1.
Matter pending before Supreme Court. The SLP pending before Supreme Court has still not been decided. List after 8 weeks. 10 weeks.
Item number 2.
May it please your lord. My lord, in this case, my lord, the villagers of the rural areas in Nagaland, my lord, they are not getting supply of potable water, your lordship, despite crores of rupees, my lord, sanctioned by the central government, your lord. And that is the case, your lordship. And in this case, my lord, we have filed an application, my lord, for taking the matter in this principal bench in Guwahati, your
So
lordship.
it's already there.
That is the miss case, your lordship.
So we are already taking the matter up in Guwahati.
My
There are orders passed by the earlier division benches in Guwahati only.
No, my lord, under the rules, my lord, Guwahati High Court's rules, your lordship can take the matter in Guwahati, your lord.
Council, we are seeing that it is already being taken up.
Oh, I do not know, my lord, they had.
There is an order of 19 January
My lord.
wherein this court has issued notices of motion. So that is, it's already, now that acknowledges the fact that it is taken up.
I am highly obliged. Yes.
Yes.
No.
Even affidavits have been received. Don't you have a copy of the affidavits?
Hmm? Affidavit?
The state has filed
They
affidavits.
had submitted their affidavit. We have also replied to that. Your lord.
All right, then proceed. What is wrong in the works which have been done? What is the shortcoming?
Now, my lord, in this case, your lordship, if your lordship stand to my lord, page 66, my lord, annexure 6, your lordship, then your lordship will find, my lord, the government of India, your lordship had granted, my lord, 10 crores 43 lakhs of rupees, your lordship, for
Yes.
this purpose, Nirmal Bharat Abhiyan, that is for the purpose of supply of drinking water, your lordship.
Yes.
And then your lordship will find, my lord, page 68. Here also, my lord, your lordship will find it is 2 crore sanction. And then, my lord, your lordship will find, my lord, page 70, your lordship.
Sir, we
It is
understand,
10
we
crores,
understand.
In this.
Now,
way,
what is the response of the state regarding these sanctions? They have utilized it or not?
They had,
State response.
now, state, my lord, they had submitted their affidavit, my lord. They have submitted, my lord, their completion report and the, my lord, amount sanctioned for that. And from that, your lordship will find the, my lord, amount sanctioned by the central governments and works done by them. Some photographs, my lord, and all that they had attached. are not proportionate, your lordship.
So that you have to counter that by filing a rejoinder. How you done that?
My lord,
Have you done that?
We have filed that.
Well,
my
let's see, read your rejoinder, please.
lord. We have filed that, my lord. Your lordship will find our rejoinder, your lordship. At page, my lord. I can read. Hmm? Now, my lord, page 6, your lordship will see. My lord, it is mentioned here that, my lord, at the below, my lord, it is mentioned here that a sum of rupees 6 crore 45 lakhs and 28,000 were release funds restaurant rural drinking water program by sanction order dated my lord, signs of the affidavit in opposition filed by the respondent too.
Hmm.
But the photographs, my lord, of
From photographs, can we make an assessment, sir? Is it possible?
Photographs, my lord, they had annexed. That is the work.
They have
done.
said so on affidavit that we have utilized the amounts and we have executed the projects. Now, whether this kind of assertion in your rejoinder, that photographs do not reveal that this much work was done. Can it be now is a matter of evidence or what?
It is their affidavit, my lord, and on the basis of that, what they have stated, my lord, if your lordship goes into these photographs, your lordship will find that these are disproportionate, your lordship.
Sorry, sir.
I would
This
like
is-
to take your lordship to some of the photographs into your lordship.
Yes, please do that.
My lord, if
But
you.
they have also said so on affidavit, Mr. Counsel.
Hmm.
So can the evaluation be done in writ petitions? Can evaluation of evidence be done in writ petitions? They say on affidavit that we have utilized, we have provided the schemes, we have executed the projects. What is there to disbelieve?
My lord, your lordship will find the works done, my lord, are disproportionate. We have just prayed for it, my lord, direction from this court to the secretary concerned of the central government to supervise the work, your lord.
Is there any complaint? If they have not done the work as per the sanctions, then you need to file complaints to the authorities concerned. We feel that they have already done their task, and if you are not satisfied, then the remedy lies elsewhere. Disposed of in view of the amendments made in the affidavit in opposition.
Hello?
Disposed of. All right.
Item number 5.
May I please, your lordship? That's why I on behalf of IS work with your lordships. Affidavit has already been filed, lordship.
Where is the refusal of respondent number 6 in the notice? Let us see. You have said so in the affidavit, but there is no remark to this effect in the notice received after service. Acknowledgement.
Page number 6, lordships. Written after service, lordship.
Yes, you have said in the affidavit that respondent number 6 refused.
Yes,
Where
lordship.
is that remark on the notice? Have you got a copy of the notice, please? The refusals should be attested by witnesses. See the notice.
No, lordship.
You have got a copy? Have you got a copy of the notice? Have a look at it.
No, lordship.
Service has not been effected on 6. Fresh steps are required to be taken. No, doesn't seem so. Yes. Though the petitioner has filed an affidavit of service on the response numbers 5 and 6, but the perusal of the notice returned after service would reveal that there is no acknowledgement of the respondent number 6 on this notice. The petitioner has stated that the respondent number 6 refused to accept the notice, but there is no such remark on the notice to this effect. Thus, fresh steps be taken. Service has been effected on the respondent number 5. Fresh steps for service on the respondent number 6 be taken in 3 days, whereafter process be issued.
Hello.
Item number 6.
6 weeks.
May it please your lordship, my lord.
Hmm.
My lord, with limited grievance of 2 villages, my lord, the petitioners approached this honorable court. My lord, they submitted representation for, my lord,
What is the law on change of alignment of a national highway?
my lord.
Can the writ court
That is why.
exercise power of judicial review
I-
and direct change in alignment of national highway?
My lord,
One judgment of Supreme Court, please cite.
yes, yes. And.
Is,
my lord,
ye-
moreover, my lord,
yes
that-
means what?
my lord,
Is there any judgment to this effect that the High Court in writ jurisdiction can direct the NHI to change the alignment?
my lord, now presently, my lord, here, my lord, TA notification has been issued. Declarative notification is not been issued, my lord, and therefore our objection that to protect the villages and the, my lord,
You just see your Google map. It
yes,
will be disastrous if the alignment is changed. See
My
the
lord,
green map, 202.
yes, my lord, 202, my lord.
See, even the slightest change will displace,
Towards south, my lord.
the slightest change would displace such a huge populace that will be impossible.
No, my lord, kindly see, my lord, Urput, that the what is there, my lord, this is another village.
Yes.
On the southern side.
Yes.
And throughout the Urput, my lord, these are all, my lord, wetland, downland, my lord. So this road goes just the middle of, through the road, my lord, that the circle officer report is.
The
also-
orange is the proposed road.
Yes,
You have shown the road in orange.
yes.
So orange road, if you see, Urput is on the right. It doesn't disturb Urput at all.
My lord, we are not from Urput, my lord.
Yes.
We are only, my lord, Paragusi and Moniari, my lord.
Hmm.
The road goes through the, my lord, these 2 villages, my lord.
Yes.
Just middle. Kindly see, my lord, that circle officer, page 87, my lord.
Objections are to be filed. But you have a right to file objections.
Yes.
The act provides for that. You file your objection.
Ma-
Let
we
them
have filed,
decide.
ma- We
It's a
already,
premature petition.
we already filed, my lord, the page
This is a premature petition, gentlemen.
207, my lord. They have not done nothing, my
So
lord.
they will consider.
My
they
lord,
will
let them
consider.
consider, my lord, 207, my lord, before respond number 2, my lord.
Hmm.
Give, let them give us a.
Mr. Das,
My lord.
we want to know whether there has been any initiation of acquisition proceedings or not.
Not yet, my lord.
So when an acquisition proceedings is initiated either under the 64 Act or
Yes.
if it is done under the new
NHI, yes.
2013 Act,
No,
there is a
NHI will
particular
do it
procedure.
NHI.
It is under NHI Act.
NHI.
So
Yes.
if it is done
There is a
under the
procedure.
NHI Act, you have a right.
My lord, page 89, 189, this is the 3A notification, 3D is pending.
Hmm.
So before that, they could consider our, my lord,
Yes.
objection, my lord. In other places, 3D declaratory notification
Hmm.
under National Highway Act has been issued. But this respect of these villages, my lord, this stress of road, my lord, they have not issued. So.
But Mr. Das, doesn't section 3C say that
Yes, yes.
you have a right,
Hearing
you
of-
can object
yes.
all these things. Then when their notification, has the notification under 3A has been issued,
Only
then you
C.
reply.
My lord, that is why, my lord, we have given, my lord, our apprehension that, my lord, without hearing, they will, my lord, do, my lord, because survey is going on. Survey is going on, my lord, and.
What is your
only-
stand?
Lordship, they have prayed for realignment, Lordship. That
Hmm.
is not possible.
That is not possible, but
Lordship,
their
because
objections, what is the status of consideration of their objections?
Instruction.
Lordship, till that, Lordship, no acquisition.
You are for the NHI? Yeah, please let us know.
So here, madam, what happened? He's, please, I only my submission before Lordship is maybe wrong also. 3C is coming 956. This procedure, when it is, when procedure is going on alignment, but it is here the change of alignment.
Hmm.
It is a change of route itself,
Okay,
because DPR already been finalized.
DPR has been finalized.
Finalized.
Okay.
Now, thereafter, TA will come, my lord,
Hmm.
2056. Then they will get the opportunity when
NHI.
TC will get it. Then
NHI.
thereafter TD will come. But here the question is, my lord, subject to this one correction, my lord, that this, he wants that route should be diverted in other.
That
manner.
can't be done. That
That
can't
is
be
the-
done.
That is our plea, my lord. Otherwise, TC will come.
What is the extent of objections
Here, my lord.
regarding what?
Yes,
Yes,
let the
See,
Supreme
all
Court.
right, they will see it. They'll consider your objections.
My lord, let them
How-
consider.
They have to, that is the mandate of law.
My lord,
How can we preach us that they will not consider?
only our prayer, my lord.
Gentlemen,
With,
this-
my lord, the hearing, my lord, opportunity of.
The Act says so. If they don't, then they will follow the act, plain and simple.
Mala, another case, Mala, here lordship, Mala, while there in the honorable, Mala, Rajasthan High Court, Mala, lordship dismissed such kind of, but this is diametrically different. There, Mala, the plea was, you construct the highway to our villages. Lordship dismissed that.
Change
While
of
sitting-
alignment is not permissible, gentlemen.
So now,
Here,
now,
my
Mala,
lord.
here is different. Here present case is that, kindly.
Gentlemen,
consider
the
our-
ultimate effect is only that same change in alignment. What is the scope of a writ petition?
Yes, my lord, Supreme Court clearly says in Narsing Ram case, my lord, that they cannot wait. But it's a
No,
small
let them
aspect.
get the instruction, otherwise on our representation, what they have
They
done.
have
Law
to
is
do it.
settled, my lord.
That is the mandate of the act.
Mala, 203, Mala, let them consider, Mala, kindly, Mala.
Dismissed. Thank you.
Mala, due to the adversely effect, Mala, I pray, Mala, let them, Mala, consider our representation. Otherwise, they will not do, Mala. Page 203, Mala.
What do you say to
Resolution
that?
number
Their objections have to be considered.
2. Yes, yes.
The-
That must.
The
be.
petitioners have
Who will dispose as
Approach
per law,
before-
my lord?
Yes.
by filing this writ petition on Article 2 to 6 of the Constitution of India, styling it to be a PIL, raising a grievance that the proposed national highway number so and so,
10117.
117,
No, 100, Mala, 17, Mala.
17.
Yes. Representation is page
Is-
207, Mala.
Just hold on, gentlemen. Is to pass through their respective villages, which might disrupt their
I did.
life and virtually destroy their habitat. Full stop.
The existence.
It is stated that proceedings under section 3A have already been started with the issuance of a notification dated, issuance of notifications dated 10/3/23,
Yes.
20th January 23, and 28th February 23.
Yeah, 21 days is over. He's supposed to give within 20 days, that is over.
We have given.
The petitioners further claim that they have filed objections under section 3C
Yes.
of the NHI Act, and the only prayer which is made before the court is that the NHI, National Highway Authorities, may be directed to consider such objections as per law.
Yes,
And counsel representing the NHI,
yes, we'll do it.
does not dispute the fact that the representation oblique objection filed under section 3C of the NHI Act has to be considered as per the mandate of the act. Thus, requiring the authorities to objectively consider the representation aforestated, dated so and so, filed by the petitioners in the letter and spirit of the act, provisions of that,
Only my lord,
the
only my lord direction should go to respondent 2 and 4.
response number 2 and 4,
My lord. That's
the instant writ petition is disposed of.
Malad, obligation.
like-
Malad, may I make one prayer, Malad? Malad, let them give one as one affording of hearing, Malad.
If the act permits, it will be done.
Permission
If
for
not,
law.
it will not be done.
Yes, obligation.
We've said that as per the act.
Malad.
Mobile look. Mobile look like-
Item number 7.
Land record is 65. Was there. Yes.
This matter may come after the vacation, Lordship,
Why,
because
sir? Why? We don't propose to hear them for the present.
Lord, they-
This is for fresh admission.
Lord-
You argue your case. Don't look at them. For the present, the matter is for admission, fresh admission.
Lordship,
We are not even proposing to hear them.
they have not,
It's an acquisition of 65.
Lordship,
There is no protest by you at any point of time. Now you come up after 60 years.
No, Lordship,
You let us know why shouldn't we dismiss your writ with heavy cost?
I'm
Writ
submitting,
appeal.
I'm submitting, Lordship.
Yes.
We filed a writ petition stating the facts that this land belonged to my grandfathers. And we have inherited land. We are the owners of the land we have shown by documents. Now, the land is under possession the respondent departments
Since,
till today, since
since,
65 till today.
yes.
The question is that still occupying my prairie is that it's a fact, admitted fact, they are occupying my land without payment of any money or anything like that. We want the land to be vacated by them. They established an office which concerned my grandfather. Some assurance were given. That office, Lordship, that subsequently. Let them.
All right. Admit issue notice. The respondents are duly presented. The copies of the appeal we provided to respective standing counsel.
Item number 8.
Oblige, Your Lordship.
Yes.
May I please, Your Lordship?
Judgment, everything has been dealt with. Yes.
It is a case challenging an order or land single judge on the ground that is narrated in page 11. That it was an ex parte order of the labor court. So the land single judge has considered that in the labor code we have not got opportunity to.
You got thrice, you got opportunities. On 3 times you defaulted by not appearing.
No, Millard, what happened, Millard? In the labor code, Millard, we engage our lawyer appeared.
That can't be
But he
a ground,
expired.
sir.
Because he expired after we engage another lawyer.
Yes. And again, it's very easy to throw the blame onto the lawyer. It's very easy. Today we'll dismiss your appeal and your client will say, my lawyer didn't argue it properly.
The labor court should have informed us, Millard.
Why should it have? You are represented. It's your duty to pursue your case. Why the lawyer, the labor court is supposed to run after the litigants? Tell us.
Because labor court was aware that our lawyer was expired.
Oh.
So after his expiry, labor should have informed us, Millard.
Let us see any application to the labor court that yes, our lawyer had passed away and that is why you can please reopen the proceedings. Where is that government?
The government is that
The council, another aspect of the matter, it was not the workmen, it was the, what you call your association who was representing the workmen.
Yes.
And your association must be having many cases out there. Can you say that one, because your associations keeps on representing many workmen in the labor courts.
maybe
Then,
the association has
then did it happen in respect of all other cases?
there are no other cases, Millard, at that time.
And then you have pleaded that you are acquitted in the criminal case, whereas the fact is you are convicted. There is a conviction on a plea of guilty. One of your grounds was that the workmen have been acquitted by the criminal court.
Yes.
Which is a wrong fact, wrong assertion. It is a conviction and thereafter released on probation. Are you aware of that?
No, as per the order, Millard.
Are you aware of this fact that they were not acquitted, they were convicted? An argument was raised on your behalf that there is an acquittal in the criminal case.
Yes.
But the fact is that it's not an acquittal.
But as per the order, it is acquittal.
Oh, let us see the order.
Page 21, Millard.
Page 21.
Page 21.
third paragraph. Having considered all aspects, I find that it is a fit case to close prosecution defendant. There being no specific
And what
ingredient.
about page 54? What is that?
I dispose of with statement of 130 accused persons are held acquitted.
What is about page 54? Which is that case? There must be more than one cases.
No.
The GR numbers are different. The GR numbers are different.
In one case, there is a conviction
Yes.
on plea of guilty. Now,
No, there is no conviction. Madam.
oh, accept the plea of guilt. Is that not a conviction? Plead guilty would be conviction, sir. Admit issue notice. Steps for service upon the respondent you are representing.
That's for number 1, your lordship.
All right.
That is stated.
There is only contesting respondent. The contesting respondent number 1 is represented. Thus, notice need not be issued.
Item number 11.
May I please?
Please.
The reply filed by the petitioner, I have sent it to the department for their comments. He has trying to draw some equivalence to some other teachers. I'm waiting their instruction, my lord.
Ms. Mazumdar submits that we
Reply, my lord, the affidavit in opposition, they have filed, my lord. That is not complete. Yeah, I have in my affidavit reply, I have annexed the government policy.
affidavit in reply filed by the petitioner has been forwarded to the department for its comments, which are awaited and instructions are still awaited. List up summer.
Any date, my lord, in the last part of the July, my lord?
27 July.
Oblige.
Item number 12.
Right, please, your lord. They have filed the affidavit in reply, madam.
Yes.
Madam, in this case, I have challenged the regulation, madam, of the electricity authority, madam.
Yes. Have you read this judgment of Raman which they have cited?
Yes, my lord.
Therein the single bench awarded 60 lakh rupees. Division bench interfered, reduced it to 30.
Yes, sir.
Supreme Court restored the order of the single bench.
Absolutely, my lord. My lord, I agree with you, my lord, that the honorable court has the power. But my lord, the main thing is that this is a compensations, this is a scheme of compensation.
So they have challenged the validity of the scheme.
Yes, my lord. On the ground that the amount that has been constrained here is less.
Obviously.
So my lord, but there is always a remedy.
Even if we apply the yardsticks of evaluation of cases in MSCT,
My lord.
this is not up to the mark.
So my lord, on that regard, my lord, that let the additional AG, my lord, behalf on the APDCL, my lord, he would be considered.
Who would be coming?
Additional AG, my lord. Additional AG would be that. So my lord, I may let the list the matter just after vacation.
Which additional AG?
My lord, PN Goswami, my lord.
All right. Then council Mr. submits that additional AG, Mr. PN Goswami, would be representing the APDCL in this petition, and thus, some time may be granted so that he can be instructed to argue the case on behalf of the corporation. List on name of Mr. Goswami shall be henceforth reflected in the call list. List on 27th July. 26th July.
27.
Item number 14.
My lord, in this case, yesterday I received the affidavit opposition filed by respondent number 10. And my lord, I have filed one on the IA, my lord. Regarding my lord, while they are relying on certain documents in the affidavit filed by respondent number 3. But I prayed, my lord, these documents are all were retrospectively effect and backdated issued, my lord. So it is a violation of the entire provision of the scheme A, 2A, as well as the rule 9 of the my lord, education rule 2014 came under Assam Privacy Council Act, my lord. And the mandatory provision of my lord, the note A and B. So on that matter, notice may be issued and that let them respond on the IA. my lord.
Your IA is not before us presently. Is there any IA? IA number 1670.
Yes, my lord.
All right. You've got a copy?
No, Lordship.
Copy-
IA
copy was
already issue notices of the interlocutory application to the respondents. Copy of the interlocutory application and the annexures be provided to the learned counsel appearing on behalf of all the respondents who pray for and are granted 4 weeks time to complete their instructions.
But here, one thing I'd like to point out, my lord, in the IA, the petitioner has prayed that, my lord, the NOC for the subsequent year 2022 and 23 should not be issued in respect of respondent number 7 and 9. Now, respondent 9 has preferred a repetition, my lord. Only last week, an order has been passed by the honorable court to consider that NOC, my lord.
We have not passed any stay in his favor.
My lord.
Only
Proceed
one
as per law.
Only one prayer, Lordship. I am appearing for respondent number 11, Lordship. I have filed my Ukalnama, Lordship, but it is some error, Lordship. I may be allowed to withdraw that and file a fresh, Lordship.
And counsel MS so and so appearing for the respondent number 11
11.
submits that there is some error in filing wakalatnama on behalf of such respondent and she may be allowed to rectify the same. Permission granted.
Obliged.
My lord, the one, my lord, is a main, my lord, we have to respond, my lord. Though he is not, response is coming from the one, my lord. So that should come. my lord.
Respondent number 1.
Yes, my lord.
In the meantime, pleadings be completed in the main PIL.
Must be.
Lordship, my name will be reflected. I will apply for respondent number 12.
Council, name of council representing the response numbers 2 and 3.
12, 1 to 12, Lordship, 12. 12.
12 shall also be, so and so shall also be.
I am appearing for item number, respondent number 8.
Give a slip to the court master, sir.
I file an affidavit in opposition. Lordship, I want to file an affidavit in opposition.
You have already made that observation that pleadings be completed in the meantime.
Must be.
Supplementary list, item 15.
Make please, Lordship. My lord, according to us, subject to losses may say, it's a case where, my lord, neither 24(1) apply of the new act applies, neither 24(2). Now, in any case, my lord, in my humble submission, my lord, what the learned single judge has committed wrong, if your lordship will kindly come to the impugn order, my lord, at page 214. Para 11. Be that as it may, in this case, we find that the quantum of compensation as has been determined by the Deputy Commissioner Tinsukia as per letter dated 27/5/23 is 22.so crore. Moreover, considered, now this is the where, my lord, moreover, considering the original award for an amount of rupees 6.3 crore and on addition of quantum of interest and solicium, they may exceed twice the amount of the award. This court is of the considered opinion that as an interim measure, the petitioner be directed to deposit 9 crore in addition to whatever amount has already been deposited. Now, my lord, the learned single judge has, calculated this amount of 9 crore on the premise that this amount of 6.3 crore, here, my lord, solicium and all would have to be added. That is not correct. If your lordship will kindly come to 146, my lord. This is already added. It's already loaded with all the components. 146, my lord. According to us, my lord, this is the award. With reference to the subject cited above, I would like to inform you that a sum of rupees 5 crore 90 lakhs only against LA case number 191 of 2012 and 39 lakhs, 26 lakhs, etc. only against LA case number 193 of 12 was fixed by the Deputy Commissioner as per Honorable Guwahati High Court's order dated so. At para 9 of the judgment dated 5/4/2011, whereby a meeting was convened on 34/2011 at DC's office chamber along with the representative of Oil India, Garden Authority of Pukanguri Tea State and the district administration, wherein overall gross value of the land of Pukanguri under acquisition was fixed at 10,07,000 per vega only for the instant case. The rate was approved as a special case and will not be applicable to other oil related cases or any other acquisition. This is what. The value of the land was fixed as per valuation report received from cycle officer at so and so, plus so and so, so and so, so and so. So this component is already included.
Mr. Chaudhary, you make your arguments before the single bench. Deposit the amount, what is the problem?
No, what I'm saying is, my lord, that we have got twofold interim prayer, my lord. We are prepared to pay that 6.30, out of which 1.5 we have already made. Rest we are prepared to pay. Now, if your lordship insists on payment of 9 crore, then my lord, the balance will not be released to them. This will be retained by the deputy commissioner, will pay. Meanwhile, my lord, Lana single judge may be requested to expedite the proceeding. Otherwise, my lord, if they take the money, my lord, it will be difficult. Supposing we succeed in the repetition.
It will be not be possible to recover.
Yes, my lord.
Yes.
The original award, the so-called award, which they place reliance in 146, is based on an order of at 126. If your lordship sees, that is an interim measure because there was a division bench order of 5/4/11 holding that the land acquisition proceeding should be completed within 6 weeks. At that point of time, even section 4 was not issued. So an interim measure was, if your lordship sees, at page 128, my lords.
Yes.
My lord, 3rd of May, 2011. Whereas land acquisition under LA Act 1894 has been initiated for acquiring land for Oil India in so and so, currently under possession of Oil India as per the Honorable High Court's order dated writ petition number so and so. Whereas approved land value as per DC Tinsukia's order dated so and so stands at 5 lakh per vega for land in Tinsukia town and semi-urban area within 3 kilometers from periphery of the town. Whereas as per the decision taken during the tripartite meeting held on so and so, as per the High Court's order between the district administration, Oil India and the tea estate, land acquisition proposal is to be submitted at current market rate. Whereas the process of zonal valuation of Tinsukia district is still underway and the approval of the state government is mandatory, it could take more than 3 months. That without the state government's approval of the zonal valuation of Tinsukia district, land valuation for oil-related acquisition as on 2011 cannot be fixed by the deputy commissioner. Whereas as the High Court order dated so and so, in the same case, duration of 4 weeks was given for submission of land acquisition proposal for the land for the in the tea estate to collector and deputy commissioner. Whereas the tripartite agreement dated so and so, both parties agreed to abide by the order of the deputy commissioner, DC Tinsukia, for enhancement of land value in so and so tea estate as an interim measure, pending approval of zonal valuation. And if your lordship sees the following page, the terms and conditions.
10,07,872.
But if your lordship sees the last paragraph, any enhancement of rate
Retrospective
at a
effect.
later rate after approval. So it was an interim measure. Based on this, they assessed it at 6.3 crores. But interest component was not there. Section 34, your lordship knows, my lord. 12% interest if possession within 1 year, otherwise 15. So it will be much more than today. They have had land of the tea garden was handed over way back in 27/11/2000. Today, 23 years have gone by. We have not got anything other than a 1.5 deposited in PF fund. Now, ultimately the award comes to 22 crores. That is a sale before the writ court. The learned single.
Where's the final award?
It's a balance, my lord. That the lordship will find.
That is the challenge before the learned single judge.
Yes, yes.
13/4/23 at page 193, read with 196.
So, Mr. Chaudhary, this is not even the 50% of the
My
award.
lords,
No, my lord.
not even the 50%.
No, my lord, that's what we said, my lord. We
Mm.
deposit the money before the deputy commissioner as
Mm.
ordered by the learned single judge.
Mm.
Only, my lord, they will be not released. Otherwise, my lord, if we succeed, my lord, there's
9
no way
crores, if
we can
interest
recover
component
the
is
amount.
added to 6.3, it will be much more than 9 crores.
No, that's a
They need
different
not
thing.
worry about that.
Interest
because
will pay.
Oil India has not paid, taken over the land for drilling exploration in 2000. We are at 2023. They have not even paid, my lord.
So
the
even if
award
we
is
go by the
22 crores.
award, 6 crores,
Yes.
apply interest
No.
per year from
No,
2000.
That is there, my lord.
What will
That
be the
we-
amount?
That we cannot dispute.
So then 15%.
So, my lord,
apply interest,
interest not the
calculate.
amount to pay.
Then just simple calculation, interest on 6
No,
crores
only thing
from
is-
2000.
Only thing is, my lord, we'll approve the learned single just to expedite the hearing.
Yes, do that.
We'll pay the balance. Man, earlier 1.5 was paid to the
Yes,
Provident
yes.
Fund because there's a request from the Garden Authority. Because they had some issues with the Provident Fund. So that is how, my lord, the amount was.
That was paid when? In 2000. No, we are in 2023, Mr. Chaudhary. This is not done. It's not done. We'll just say that you want to request the learned single judge for expediting the hearing. Nothing beyond that. After arguing the matter for some time, this intra-court appeal is directed against so and so. After arguing the matter for some time, Mr. Chaudhary submits that his clients, rather than entering into the validity of the interim order, so and so, the petitioner appellant would be better advised to request the learned single judge to expedite the hearing of the writ petition. With the efforts at liberty, he seeks permission to withdraw the instant writ appeal. Hence, the writ appeal is disposed of as withdrawn.
Deep level.
Deep level.